Hello, dear students. This is my second video on the company meetings. I'm Dr. Prajna Mattelli, who is working in Government First Grade College, Kittur, who has prepared more than 150 videos on different topics. Please subscribe my channel so that you can enjoy my videos and it will be benefiting your examinations. Here in this particular video, let us understand the requirements, essentials of a valid company meeting. Here we have to go with the ideal things. In my last video, I have discussed the meaning of the company meeting, types of company meetings, and also the business which will be discussed in the company meetings. Here in this video, let us understand the requisites of valid meeting. Proper authority to convene. That means for the company meetings, the person who is conducting the company meeting is called as authority to convene. Who calls, who is there to arrange for the meeting, who is behind the meeting is called as proper authority. There should be proper authority to conduct the meeting. Then only it becomes valid. Otherwise, it is not valid. Then proper notice should be given. What should be the contents of the notice? Let us discuss it afterwards. Quorum present. How many uh, members are present over the meeting? That is called as quorum. And a competent chairman should be there. There should be a chairperson in the meeting compulsorily. He should look after the proceedings. Agenda and lawful business should be there. Agenda means the matter to be discussed in the meeting. Proper voting procedures are to be followed, and there should be recording of minutes under section 118. Let us discuss all these things one after the one. First one is notice. As per the section 101 and 171, 173, there should be notice for every meeting. If it is shareholders meeting, then minimum 21 days before notice should reach every member. And both for the board meetings, uh, the notice should be prepared and sent to all the board members, and at least it should reach 7 days prior to the meeting, so that why this time restriction is there, why you should reach 7 days before, why 21 days before the notice should be reached to the shareholders, because they have to prepare. They should know what is going to be discussed in the meeting. They should prepare themselves to attend the meeting, because meeting doesn't want the member to be present only physically. They should contribute to the meeting, means they should know the things, they should be able to discuss in the meeting. Therefore, minimum 7 days before, every director should be given with the notice. Minimum 21 days before, every shareholder should be given with the notice of the meeting. Then what is this notice? Notice should contain the date of the meeting, time of the meeting, and venue of the meeting. Then the nature of business. That means what we are going to discuss in the meeting. And explanatory statement for special business. That means as per the section 102 of Indian Companies Act, there should be explanation what the special matter is and what is going to be discussed, etc. And here quorum is very important. Quorum means the number of members present over the meeting. As per section 103, general meetings of the company should have quorum. That means the members should be present over the meeting. If it is a public company, the rules is different, and if it is a private company, the rules is different. Here, in case of public company, 5 members minimum should attend the meeting. Up to 1,000 members also, minimum is 5. If the total members are more than 1,000, then the quorum is 15 members. At least 15 members should be present over the meeting. And the members, if they are more than 5,000, at least 30 members should be present over the meeting. And what about the private company? The rules is different. Here, minimum 2 members personally present in the meeting. Then quorum of board. Here, 1/3 of total strength or 2 directors, whichever is higher. That means if total directors are 6, 1/3 is equal to 2. So 2 directors should be present, up to 6 directors. And if the total directors are 8, then 1 or 9, then 1/3 means 3 directors should be present over the meeting. Then only it is called as quorum. Why the quorum concept is there? See, if minimum members are not attending the meeting, then whatever the discussion is going on, whatever the decisions are taken over the meeting, will be having no validity. Therefore, quorum is important from the point of view of company law. Importance of this quorum, that is, it ensures collective participation. Everyone is participating, everyone is interested in the discussions and the decisions. That is the indication. It prevents arbitrary decisions. Otherwise, what happens if only few members are present over the meeting, and if they are all likely minded, they will take one-sided decisions. Therefore, to avoid this kind of things, uh, more number of members should participate in the meeting. What do you mean by resolution? Resolution means a formal decision passed by members or directors. If it is the meeting of members or shareholders, they are going to take the decisions. Otherwise, if it is a board meeting or directors meeting, they are going to take the decisions. This formal decision is called as resolution. So, under the Companies Act 2013, there are 2 types of resolution. One is called ordinary resolution, and another one is special resolution. What do you mean by ordinary resolution? It is passed by simple majority. Simple majority means 51%, more than 50%. That means more than half of the gathering. What they support is called as decided. What is special resolution? It requires at least 75% majority. It matters requiring special resolution. That is change of company name, alteration of articles, then reduction of share capital. Such kind of matters need maximum support. Therefore, more than 75% of the people or the members should support the decision. Then the resolution is passed. It is called as special resolution. What about the voting? Methods of voting? There are many methods in the meeting. The methods of voting, that is show of hands. So the chairman can ask the members to raise their hands if they are agreeing with the things. And then they will raise their hands. Hands will be counted, and that is if half the more than 50% of the quorum or the members are supporting, then it is called as okay, voting is over and the resolution is passed. Otherwise, poll method can be followed. Poll may be of electronic voting, it is also possible. Postal ballot method can also be followed, or electronic voting, that is e-voting, is also valid. Yeah, e-voting is mandatory for prescribed classes of companies to enhance transparency and shareholder participation. So such kind of companies, e-voting is going on. What do you mean by proxy? As per section 105, proxy is a member. Any member can appoint another person as proxy to attend and vote. If any member is not being able to attend the meeting physically, he is busy with some kind of work, he cannot attend the meeting, then he can send another person. Another person who is representing the original member is called as proxy. Proxy need not be a member. He is a person who has been appointed by the original member. Proxy form must be submitted within prescribed time before the meeting. So, wherein in proxy form, the original person writes his name, he makes a signature, then he writes the person who is acting as proxy, and he is sending the proxy form to the company. Rights of proxy. What the proxy can do? He can attend the meeting, he can vote on poll, and he can participate as authorized. Then minutes means while meeting is going on, the proceedings are to be written. It should be in written form. That is as per section 118 of Indian Companies Act. That is called as every company must prepare and maintain minutes of meeting. Minutes should contain fair and correct summary of proceedings. Minutes must be signed and preserved permanently, and there should be it should be in a book form so that every person who is interested can read the minutes. Importance means legal evidence. It's a legal evidence of proceedings. It ensures transparency and accountability. Then the role of secretary, what he is going to do under the Companies Act. Before the meeting, he has some kind of work. During the meeting also, he has to undertake some responsibilities. And after completion of the meeting also, he has to perform some duties. So before the meeting, he has to draft and issue notices. He should prepare agenda and explanatory statements. And here he should ensure statutory compliance. So these are the duties of the secretary before the meeting. Then during the meeting, what he is supposed to do? He should assist the chairman. There will be a chairman in the meeting. The chairman will be acting as the supreme power in the meeting, so he may be in need of some kind of assistance. That assistance will be done by the secretary. He ensures the quorum. He should count the people, how many members have attended the meeting. He should count them, he should record it. Then, what is the quorum of the meeting? He should decide whether it is there or not. He should decide. If the quorum is not there, meeting is to be adjourned. And after the adjournment time, the meeting is to be conducted. And the secretary should record proceedings and resolutions. He should write down everything. After the meeting, what he is supposed to do? The secretary should prepare the minutes, should write down what all the things discussed in the meeting, what were the opinions, what were the discussions, what were the arguments, what were the points raised, and who supported it, and who argued against that. Everything details he has to write. That is called as minutes. Then he should file resolutions with the registrar of companies. He should take them, the resolutions, and he should file them. That is the duty. He should maintain statutory registers and records. So, duties of the company secretary: he acts as compliance officer. He advises board on legal provisions. He ensures adherence to secretarial standards issued by Institute of Company Secretaries of India. He maintains corporate records, and he facilitates corporate governance practices. And What are the importance of company meetings? It strengthens corporate democracy. It enhances shareholders' participation. It ensures transparency and accountability. It enables lawful decision making. It promotes effective corporate governance. So, as a conclusion, we can say that company meetings are governed by the Companies Act 2013 and secretarial standards. Proper procedures regarding notice, quorum, resolutions, and voting are essential for validity. The company secretary plays a crucial role in ensuring legal compliance and smooth conduct of meetings. So, dear students, the same video is prepared in Kannada medium also. I have prepared Kannada medium slides and explanations are given in Kannada. So if you are interested in writing the answers in Kannada medium, you can refer those videos. And I request you to give the feedback. Do you need more explanation? Do you want more points? Do you want something to discuss? So just give me the feedback, and I wish you all the success in the examinations. Okay, fine. Thank you. And I request you to give the feedback. Thank you.